Honor. Christopher Prejudice on behalf of the state.
Good morning.
Good morning, Dan Hempy for Mr. Pinkerton, who's present to my left.
Good morning. The court is in receipt of the motion for reconsideration, as well as the opposition filed by Mr. Hempy. You may have a seat, Mr. Pinkerton. And beginning with the state, as move on. Mr. Bridges, do you have anything to add to your written motion?
Just a couple of things I wanted to highlight, Judge. Basically, my motion is in two parts. The first part addresses the time from August 3rd, 2006 through August 24th, 2006. I've included transcripts of the proceedings which clearly show that defendant, by and through counsel, did request a continuance as averred in my declaration and argued on October 9th, and I would ask the court to consider that. And then with regard to the second part, I've addressed the issue of whether or not the motion should be granted without prejudice versus with prejudice. I've set out essential and case laws that stemmed from that, and basically there are several factors that the court needs to consider when making that determination, including the seriousness of the offense, the factors that led to the dismissal, and the adverse impact of reprosecution. My arguments are stated within my moving papers, and if the court has any questions about any of those, I'd be happy to address those at that time.
Yes, I have a couple of questions, Mr. Bridges. First of all, as to, I guess, the first part of your position or your argument, you are relying on Rule 60, correct?
I'm actually, Judge, and Mr. Hempy, I think, can agree with me on this. There is no specific rule within the rules of penal procedure which govern a motion for reconsideration. I know it is the practice of the courts in this circuit, and in fact, Your Honor, encouraged me to file a motion for reconsideration, though there is no specific penal rule that is on point. Rule 60 governs the rules of civil procedure, and I think the courts in this circuit have looked at that and by analogy extended the logic of that rule, that there should be a motion for reconsideration allowed in criminal cases, but there's no specific rule in the HRPP on point.
Is that the basis upon which you are relying for this motion?
Well, it would be the analogy to Rule 60, not Rule 60 per se.
Okay, and if we look at, well, if it's not Rule 60, then what is the basis?
The basis is this court in the circuit it's been the practice, and I don't know if there's a specific local rule on point, to allow motions for reconsideration on criminal matters, analogizing it to Rule 60. And so I think it's based loosely on Rule 60, but it's not Rule 60 per se.
So is there any part of Rule 60 of the Hawaii Rules of Civil Procedure that you're using and other parts that you're not relying on? Is this a pick and choose?
No. I have read Mr. Hempy's response, and Rule 60 does set out several reasons for a proceeding to be, for a final judgment to be relieved. They include mistake, inadvertent, surprise, or excusable neglect, and then there's a provision for newly discovered evidence, a provision for fraud, provision for the judgment being void, and a provision for the judgment being satisfied, released, or discharged. Some of those may or not be applicable to criminal cases. Obviously, this is the civil rule. But looking at that by analogy, if you look at subdivision 1 of Rule 60, it allows relief for reasons of mistake, inadvertence, surprise, or excusable neglect. And I think that would be the section that would be most on point for this type of case.
And what particular part of subsection 1 are you relying on?
Well, I think this situation with regard to the August 3rd date would go under mistake, because there was a mistake in the court records, and also inadvertence and surprise and inexcusable neglect all would fit. Because I think we can all agree that had the court records, the minutes from the district court of August 3rd, been complete, had a complete set of minutes attached to it, had the court records been complete with regard to the stipulation to allow Mr. Harrison to withdraw, that we wouldn't be here today. The court would have had that in its files on the hearing date on October 9th.
You're relying on the district court minutes?
I'm making reference to the district court minutes, which were absent, as the court noted, at the October 9th hearing.
And Mr. Bridges, you're not stating to this court that the minutes of the district court are the official record of the proceedings that occurred in the district court?
Actually, Judge, they are. The district court is a court of record, and the minutes are the official record of the district court proceeding.
But is it the minutes that you're relying upon? And you would note that these are not verbatim minutes, of course.
Correct.
Okay.
They're summary minutes. Yet the minutes from August 3rd, 2006, they didn't even have a summation of what happened. If you recall, on October 9th, when we had the motion hearing, you asked me if I had seen the minutes from August
That's
3rd,
correct.
2006, noting that a continuance was requested. And I stated to the court that I had not. And Your Honor, you yourself noted that those minutes were lacking as to that information. Clearly, that's the most important thing that happened on that August 3rd, 2006 court hearing day. The matter was continued at the request of defense counsel.
Okay, so your position is that the summary minutes, which you admit are not the verbatim record of the proceedings that occurred below, you're saying that the absence of certain things makes it a mistake in the minutes.
Yes.
Okay, and that's what you're relying on. You're analogizing this to Rule 60, subsection 1 of the Hawaii Rules of Civil Procedure.
Correct.
Mr. Bridges, you're not relying then on that you just newly discovered the taped proceedings?
No.
And you're bringing it to the court's attention?
We knew the tape proceedings existed. What we weren't aware of is that the minutes were lacking until the court brought that to our attention on October 9th, 2007. So in order to have the record complete, I personally requested that recording, and I personally sat there and spent several hours transcribing it so that this court and other courts would have the option to see what really transpired on August 3rd, given the absence in the minutes.
Any reason why you didn't do that earlier?
Well, it's never occurred in my practice within the circuit that the minutes were missing complete information about what occurred at a hearing. And so it's normally, when I look at my file and my file's notes, which are contained therein, they comport with what happened at court. And it's clear when I relied on my notes were accurate, that in fact, the court made reference to Mr. Harrison being allowed to withdraw. The public defender was newly appointed. Mr. Moon wasn't even present in court, much less ready to proceed. And if you look at the transcript, what happened is Ms. Renty-Cruz appeared with Mr. Pinkerton, indicated that he qualified. Judge Cinda asked if they wanted a continuance. Ms. Renty-Cruz indicated that they did. And then when we were setting out dates, Ms. Renty-Cruz made it very clear to the court that it was Mr. Moon that was going to be doing the preliminary hearing. And then they took a brief recess so Ms. Renty-Cruz could go upstairs and find Mr. Moon and make sure that the proposed date was going to be okay with his schedule.
And Mr. Bridges, when you prepared your declaration that's attached to the memorandum in opposition to the motion to dismiss,
Yes.
what were you relying on? If not the tape proceedings, were you looking, and if not the district court minutes, which this court pointed out to you at the last hearing, what was the basis of your declaration?
Primarily, it was the prosecution's file and the notes therein, and accompanied that file. I also looked on Ho'iki for some of the court dates, though I can't be specific as to which.
Right, and I have one more question before I hear from Mr. Hempy. I believe in a prior pleading, Mr. Hempy had brought it to the court's attention, and there had been no objection by Mr. Guyot at the time about a former plea agreement between the state and Mr. Pinkerton. And this had to do with the state's willingness to dismiss the charges, provided Mr. Pinkerton would agree basically to two things: that he would remove, I believe, his website, and that he would leave the jurisdiction. Now, I guess I'd like you to reconcile the fact that the state was willing to dismiss the charges on those two conditions with what appears to be a very strong argument or very strenuous argument on your part about if the court is to stand on its previous dismissal, that it be without prejudice versus with prejudice. And I'm trying to understand how to reconcile those two positions.
Well, I concur with the court that that previous plea offer, which never was an agreement because there was never any acceptance by Mr. Pinkerton and or his counsel, is something that is of concern. I've seen that on Mr. Pinkerton's website. It's my understanding, and I wasn't involved in those negotiations, that Mr. Minatoya, who was our former first deputy, and Mr. Guyot wanted to alleviate some of the ongoing problems that were occurring with a specific defendant. And so they made this offer for this case to go away in exchange for the terms noted by the court and possibly other terms. I don't have a written copy of that in front of me, Judge. But that plea agreement is of no effect. It was never accepted prior to any expiration date, and it was never indicated by the defendant or his counsel that they ever wanted to accept that. So because an offer was made as part of a global plea agreement, I believe it possibly encompassed multiple cases, because at the time Mr. Pinkerton had multiple cases pending. That agreement is of no effect, even though at one point Mr. Guyot indicated a willingness to dismiss the case, but that was contingent upon other things occurring, conditions precedent. And since none of those conditions occurred and no acceptance of that plea agreement occurred, that agreement was no longer in place at the time of this motion.
All right, then I have a somewhat related question to that. I believe Mr. Hempe in his opposition made the argument as to the prejudice to Mr. Pinkerton if this court were to grant the state's motion for reconsideration. And in particular, I'm looking at the fact that I believe the state had conceded on most of the period of time in arriving at your position at the last hearing. And I believe Mr. Hempe had argued to the effect that basically Mr. Pinkerton, if this court were not to stand on his prior decision, Mr. Pinkerton would be again left waiting for several months out, if not years. And it basically, the situation, as I understand Mr. Hempe to argue, would be compounding a bad situation, and where you have a defendant who ends up waiting years to go to trial. And I'd like you to address that. Again, I'm looking at the second part of your argument.
Well, this case, Judge, as of this argument right today, is approximately a year and a half old. The incident, I believe, occurred on either March 5th or March 6th, 2006. And if I could just check my notes real quick. It was March 5th, 2006, that Mr. Pinkerton was arrested and had his altercation with the police officer. Two of the charges Mr. Pinkerton faces are first-degree assault against a law enforcement officer. They're felony charges for which the statute of limitations is 3 years. Mr. Pinkerton is not in custody on this matter, so he has no oppressive pretrial incarceration. To the state's knowledge, there hasn't been any loss of witnesses or evidence on this matter. And as I noted in my moving papers, of the total amount of days that had passed between the arrest and then the motion hearing, I believe it was, correct me if I'm wrong, it was 596 days. 398 of those days were not chargeable to the state. They were at the request of or with the consent of the defendant, primarily by way of continuances that the defendant agreed to. So if you look at that, the balance, we have 398 days that are not chargeable to the state, and based on the court's calculation, we had 198 that were chargeable to the state. That's 2 to 1. So for every day that was chargeable to the state, 2 were chargeable to the defendant. And that's one of the things that the court should consider when balancing the amount of time that has passed. If you look at under like a Sixth Amendment analysis, in the seminal cases, Barker versus Wingo, United States Supreme Court case, there's a 4-pronged test that the court uses in that type of situation to determine whether or not a speedy trial right has been violated. They look at the length of the delay, the reason for the delay, and it's the reason for the total delay, the defendant's assertion of his right, and any actual demonstrable prejudice to the defendant's case, including oppressive pretrial incarceration, loss of witnesses, fading of memories, that type of thing. One of the factors that the courts have instructed us to look at in determining whether or not there's actual prejudice to the defendant is the legislative feelings on it by way of the statute of limitations. So generally, if we're still within the statute of limitations, unless the defendant on a Barker versus Wingo type analysis shows actual strong prejudice, the court's gonna weigh that in favor of the state if they're still within the statute of limitations for the main charges. And in this case, we're only halfway through the statute of limitations, which the Hawaii legislature has set at 3 years for these types of cases.
Right, thank you. Mr. Hempy, anything to add to your written opposition?
Yes, Your Honor, I'd like to and respond if I may to
Yes.
some of those points. I'd like to start by just reminding the court what it obviously already knows, is that at the original hearing on this motion to dismiss on, I think it was October 3rd, a few weeks ago, the state had the burden of proof. The state had the burden of showing this court that there was less than 180 days of excluded time. Prior to that hearing, we now know that the state didn't even check the minutes of the district court. So they can't rely on the minutes today and say, oh, it was a mistake. They didn't even check the minutes before that hearing. They relied only on notes in their file. They didn't check the video. They relied only on notes in their file. You know, it's true there's no motion for reconsideration contemplated directly in the rules of penal procedure. I brought those motions. They're done. I'm not actually sure how or why they're done after doing the research on it, but they're done. But in any event, if you look at Rule 60 in the civil procedure rules, they talk about, in terms of newly discovered evidence, which this is really, he's calling it a mistake, but he didn't discover it until after he lost. They talk, and the point is that the rule requires due diligence in the first place. You can't fail to do your homework, come to court and lose, and then go do your homework and say it's newly discovered or it was a mistake. And if you look at the case law that interprets Rule 60, it says the purpose of a motion for reconsideration is to allow the parties to present new evidence or arguments that could not have been presented during the earlier adjudicated motion. And reconsideration, this is a direct quote from the case. It said in my brief, reconsideration is not a device to relitigate old matters or to raise arguments or evidence that could have and should have been brought during the earlier proceeding. All they had to do was check the videotape. All they had to do is check the minutes. And the minutes would have said, well, there was no continuance, and then they would have said, well, that's not consistent with their notes. That would have led them to the videotape. So what you really have here is just, a do-over. We lost, we don't like it, we're going to do our homework after the fact. It's a do-over. Another point, a very critical point to this opposition is also, I'm looking at my notes from the hearing on October 3rd, and the state conceded 144 days. They conceded the period of March 5th through April 27th. That's really not what's relevant. But they also conceded in open court, August 21, that was the date of the indictment in circuit court, to November 20th, that was the date of the hearing where Mr. Guyot asked for the mental exam. And that was 91 days, and it was those 91 days were conceded in open court by the state. Now, when we look at this motion to reconsider, based on the tape, and I saw the tape, it says what Mr. Bridges said. But when you look at their motion to consider, they're seeking the court to give back not August 21 through November I'm sorry, not August 3rd to August 21, the 18 days that's at issue here. They're actually asking for the court to give back August 3rd through August 24. They're asking for 21 days. They're asking for, I'm sorry, I mixed that up. They're asking for 24 days, not 21. If I draw it, it's clearer, unless
That's
the
fine.
court,
You may,
you understand what I'm saying. But
Yes, you may bring the easel up and use it up there.
because I think one of the real key things here is, I'm confusing myself by not writing it. One of the key things is, they conceded August 21.
Can you put the board forward, please?
Got it? Okay, thank you. Back at the hearing, I have under my notes, I'm sure the court has the same, it says conceded August 21 through November 20th. Now, in their motion for reconsideration, they look at the hearing and they say, wait a minute, back in district court on August 3rd, the defendant asked for continuance to August 24. And so they want to get 21 days back. But the thing is that even if they could get a second bite at the apple, having completely failed to do due diligence, completely failed to show new law, even if they could do that, they can only get August 3rd to the date of the indictment. Now he's going to argue that the law doesn't support that, and in fact, I think the law does talk about the date of indictments being a triggering event, but in any event, they stipulated. This isn't just a mistake in court minutes. They stipulated in open court that August 21 through November 20th. So we've got this 3-day overreach here in this motion, even if their motion is valid as to 18 days. Is not valid as to 21. They agreed to it in open court. How many times have I gone to court, made some stipulation, lost, and then gone home and just, beaten myself over the head and wished I hadn't made that stipulation? You just don't get to come back and say, oops, my strategy and my analysis was wrong. Please, can we have a do-over? Another thing I want to point out is that the court, actually, we didn't finish the analysis in the other hearing because we had already gotten to 198 days. And I had other time alleged in the original motion. If the court were inclined to do something with this motion to reconsideration today, I'd ask that it be remanded for, set back for more hearing on those other days, not simply undone. But I think it's really kind of a sharp practice to come into court and unstipulate something that was conceded because of a lack of due diligence. So that's what I have to say about that. And as to the prejudice analysis.
Well, before you get there,
Okay.
what is the significance of the prior concession and the position being taken by the prosecutors now? You're looking at the 3 days.
Yeah, because if they get back, they're asking to get back 24 days.
Right.
I think that's, and we're at, was it 190?
21 days?
I'm sorry, right, they're asking to get back 21 days. This court was at 198. If they get back 21 days, we're at 177. If they only get back 18 days, because they already gave up 3 of them, we're back at 180 and we have the same result. Even if this court does reconsider, which I think, again, I object to the court reconsidering, it's just improper based on the due diligence. So that's my answer to that. It's dispositive.
You may move on
in
to
that
the
circumstance.
prejudice argument.
Well, again, I think the thing with the prejudice argument is nothing has changed from when the court ruled. maybe the number of days has changed, maybe. We certainly don't concede that it did. But the prejudice analysis, there's nothing new in their moving papers. And the court looked at those factors. Mr. Bridges argued Barker, Wingo. He reminded the court of the factors. The court stated in open court that it considered the factors in the analysis, and the court ruled. And there's nothing new. It's just, really, it's nothing more than a second bite at the apple. It's improper.
Okay, thank you. Mr. Bridges, as we move on, any final words?
Yeah, just with regard to the 21 versus 18 days. When I initially was doing my Rule 48 analysis on this case, I was looking at the original Rule 48 date that was put into place for the August 24th, 2006 hearing, I believe it was, the initial appearance after, August 28th, 2006 hearing, where there was the entry of plea in circuit court in front of Judge Masuoka. And on that calculation, they had recalculated Rule 48 as restarting with the August 21st indictment. Subsequently, between the filing of my papers and the hearing, I had a chance to look at Mr. Hempy's opposition, and I think Mr. Hempy correctly had pointed out that because there was no motion for dismissal by a defendant prior to the new indictment, the new indictment would not be a trigger for Rule 48b-2. And if you recall at the motion hearing on this, when we were talking about those conceded days, I argued to the court that it was conceivably arguable that the period of time from August 21st through August 24th should be chargeable to the defendant based on Rule 48c-3. If you look at the August 3rd date, it's very clear that while we're still within Rule 48 time, the triggering event having been Mr. Pinkerton's arrest and the setting of bail, there was no re-trigger from the indictment. And in fact, under Rule 48c-3, August 3rd to August 24th, a period of 21 days, was excludable because it was a period of delay of the commencement of the trial that was caused by a continuance granted at the request or with the consent of the defendant or the defendant's counsel.
So you're saying that at the prior hearing, the concession that you made on the record was incorrect?
Yes. And at that hearing, I pointed out to the court that from the 21st to the 24th was arguable under C-3.
Okay, anything further?
No, Judge.
All right, thank you. As I said, the court has read the motion as well as the opposition filed by the defense. And there are several things about this case that the court finds particularly bothersome. First of all, both counsel had ample opportunity to argue your respective positions at the prior hearing. As pointed out by both counsel, the analogy that the court is applying is to look to Rule 60 of the Hawaii Rules of Civil Procedure. Mr. Bridges, I heard you argue this morning that you are relying on subsection 1, and your argument is basically that there was a mistake, and that is the basis as to why this court should reconsider its prior decision. Your argument, as I understand it, is that the mistake was in the court's minutes. And because there was a mistake in the court's minutes, the court should reverse itself. Now, I think there's some confusion here about the reliance on the district court minutes. The minutes, the written summary minutes of the district court are in fact official minutes. There is no, well, I guess what the court fails to understand is how the prosecutor's office, as argued by Mr. Hempy, and in the preparation of your declaration in particular, Mr. Bridges, when you attest that the statements in the declaration are true to the best of your belief and information, the court would expect that you would be relying more than on what a fellow deputy prosecuting attorney remembers or cursive notes in a file. There appears to have been no more due diligence given to the state's position other than to rely, again, on somebody's notes in somebody's file. It was not until the court brought out the district court minutes, was there any discussion about that? So, Mr. Bridges, I find it very difficult to buy into your position that had the clerk in the district court taken more detailed minutes, or had the minutes not been a summary minutes but verbatim, that this would not have occurred, that the court would not have made the decision that it made. And I find that bothersome. In addition to that, Mr. Hempy did point out, and as Mr. Hempy referenced, it is in the court's own notes, that the concession was made by the state between the dates of August 3rd to August 24th. And again, I find it very bothersome that, Mr. Bridges, today you would tell the court, well, that concession was a mistake also. And therefore, the court should reconsider its position and rely or base its position today on what you're correcting today on the record. The court is also concerned because basically when a Rule 48 motion is filed and an opposition is filed, counsel, you're given ample opportunity to prepare and to take your best shot with the court. And both of you know that for a court to reconsider its prior decision, there has to be arguments that are persuasive, so that the court can in fact make an intelligent decision based on a real basis. And let me tell you that while courts do not readily reconsider their own positions, I can tell you both on the record that this court has in fact reconsidered its own prior decisions. I'm not adverse to doing that. However, I take it very seriously when a reconsideration is done. And I weigh very heavily what information could have been or should have been brought to the court in the first instance. And I note that the state obtaining the actual recording of the district court minutes, I fail to see why that was not obtained at the first go-around. And it's quite bothersome. And it really makes the court wonder as to how much effort is put into the oppositions to such motions. Now, as I stated, regarding the court's decision to dismiss this matter with prejudice, the court had in fact considered all of the factors, not the least of which was the age of the case and the delay that was involved in bringing this matter to trial. And Mr. Bridges, you argued about the legislative intent. I don't think the legislature ever conceived that it would take several years for these types of charges to come to trial. And I certainly don't believe that was their intent at all. Now, I'm going to hold the state to its concession that was made on the record previously, and that in and of itself would basically defeat the motion that the state has brought. But in addition to that, I state for the record that I fail to see how the state could not have brought this information to the court's attention at the prior hearing. And I find that there has been a lack of due diligence on the part of the state. I also find that summary minutes of the district court, which do not contain all of the bases upon which the state relied in its declaration in opposition to this motion, is not a mistake. It does not make the district court minutes wrong. And for those reasons, the court is denying the motion to reconsider. Mr. Pinkerton's case, this is in criminal number 0610163, which the court dismissed with prejudice at the prior hearing, stands dismissed with prejudice. Mr. Hempy, I'd like you to prepare the order once again. Have that order filed with the court within the next 2 weeks.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. And we'll take a short recess while